Think so?
I'd like to call this special meeting of the Porter County Election Board to order. We'll begin with the Pledge of Allegiance, please.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. Roll call, please.
President Roche,
Here.
Vice President Lowe,
Present.
Secretary Bailey here, Member Bangs,
Here.
Member Chittister.
Here. All right, the next item on our agenda is candidate challenge. I'd like to begin this section of the meeting by reviewing some things. First of all, that proper notice was made under the provisions of the open door laws, and that this special meeting had been posted in accordance with the rules. I think the board can certify that that has taken place. I think at this point we'll ask anyone who plans to speak on behalf of the challenge to rise and be sworn in to give testimony. Raise your right hand,
We
please.
need probably the candidate who's being challenged to stand as well. Yeah.
Please. Raise your right hand and I'll read this and then you can affirm when I'm finished. Do you solemnly swear under the penalties of perjury that the testimony you are about to give to the Porter County Election Board is the truth, the whole truth, and nothing but the truth? Please say I do.
I do.
Thank you. I will set some rules of the road. I think some of the guidance that's been passed around is that we should allow 15 minutes for the challenger with 5 minutes of cross conversation if you have any questions of the challenger. And then we'll reverse roles and give the candidate 15 minutes and 5 minutes to cross upon him finishing. If either side needs more time, you can ask the board to extend your minutes, and we will offer that same opportunity then to the other party. So I think with those rules in place, we can begin by asking the challenger to come forward.
Chair, I just want to acknowledge the fact that what was timely filed, there is a copy of all of what was timely filed with all of you. So in a copy of that was made, it says the dear sir, madam,
Yes.
and there's several attachments. That was all part of the initial filing by the challenger,
Okay,
okay?
thank you.
You also have in front of you another stack that looks like, let's see. Sorry, you also have a stack of what was filed with the candidate. Okay, that's the first piece. That was filed with the candidate. Second packet is what the challenger filed. And then the third packet that you have is, but we've set it aside and we've separated it out because we didn't know what the board's pleasure was going to be with that. But there was additional documents that the challenger wanted to file as of September 7th that was not part of the original filing. So I want to note that you have a copy of it, but it wasn't clear as what you guys wanted to do with that set of documents. You also have a set of documents that the challenge candidate has, but he did not want to make it part of the record quite yet because that he kind of felt like he just didn't want to put everything out there at this point. So that's kind of held off for your determination. And that would be part of whatever the candidate wants to offer up.
Okay. Okay, so all of these documents were received in a timely fashion, and they're all legitimate in terms of filing deadlines? Everything we have here?
Yes, I believe there's an actual
Back
deadline.
up. So there was a challenge made about the candidate, and that was,
The deadline was August 26th to receive the challenge, and that was received at that time. But what Nicolai was trying to, the first two portions are what were received by the office by August 26th, the new deadline.
So you-
And additional records requests were received for other reports, and that would be your third stack. Is what was provided after that. So basically, the first two stacks of papers were received by the challenge deadline. So anything after that was research done after that deadline. We're not sure if that matters or not, but on record, there was two sets of documents.
So, yeah, so the deadline for the challenge was August 26th. Nowhere does it say that additional documentation cannot be provided.
That's correct.
So
Yeah.
these two stacks were
correct.
provided August 26th, which was the deadline. And then afterwards, we
More
received this
documents
one.
were provided.
And it's not
Correct.
really clear if they're even required to supply you with it in advance or not.
Right.
Everything is out there, that's what we have received. And we did ask if they wanted the board to view anything in advance that they provided to us, so that's what you have.
Okay. Well, I think we're ready to hear Ms. Evans, or,
What I did do.
tell me when you're ready to begin, because I will start a timer, and I will let you know when you have about a minute left.
Okay. What I did do is make copies of what I'm going to say, so if that would be helpful to have that in front of you, because I do make citations to Indiana Code. I do have copies for everyone and for the challenger as well.
okay, sure?
Is that different than what you've already submitted to us?
It is.
Or is
That's
it
what I'm
part-
going to say right now.
Okay.
Thank you.
Thank you.
And I apologize for the amount of materials. That didn't make your job any easier. Okay. And hopefully I didn't give away my copy.
You need one back?
No. No, no. I'm not good enough to talk without forgetting things, so. And I'm also not good enough to talk without my voice cracking sometimes, so I did bring a big thing of water. And hopefully that, there we go. Okay, if you want to start the timer?
Okay.
All right. Thank you for scheduling this hearing and giving me the opportunity to speak. My name is Cheryl Evans, and I'm here today to challenge the candidacy of Mr. Robert Glossner for the office of Westchester Township Board Member. I believe Mr. Glossner has not met the qualifications to be a candidate. There is also a question over Mr. Glossner's legal name, which appears on all the filing documents. Further, a failure to comply with statutory filing deadlines for his election documents also renders his candidacy void and non-existent in the eyes of the law. His candidate filings have violated Indiana campaign laws, in my opinion, and there is a possible campaign finance violation that I wish to bring to your board's attention as well. Mr. Glassfener is seeking to have his name included on the general election ballot under the provisions of Chapter 313.1 of Indiana Code concerning early candidate vacancies. Under Indiana Code 313.1-2.5, a candidate seeking to fill a candidate vacancy under this chapter must comply with requirements imposed under Indiana Code 3-8-1 for the office. One of the requirements under 3-8-1 of Indiana Code, specifically Indiana Code 3-8-1-33, is that in order to qualify as a candidate for local office, a candidate must file a statement of economic interest, which is the CAN 12, in accordance with Indiana Code 3-8-1 for the office. I believe Mr. Glassfener's, I hope I pronounced it correctly.
You're fine.
Okay. Statement of economic interest is materially inaccurate. Mr. Glassfener did not disclose his involvements with several businesses listed with the Indiana Secretary of State as active, which I believe should have been disclosed on his statement of economic interest, his CAN 12. There are also questions over his legal name, employment, and marital status. These are not minor discrepancies, but are material. Black's Law Dictionary defines material as of such a nature that knowledge of the item would affect a person's decision-making, significant, essential. Something that would affect a voter's voting decision is therefore material. Including those businesses on Mr. Glassfener's statement of economic interest, his CAN 12, could have raised questions about those businesses by voters, organizations such as the League of Women Voters, or the news media. Those questions could have led to discovery of Mr. Glassfener's bankruptcy filing or collection lawsuits involving some of his business interests. Mr. Glassfener is running for Westchester Township Board member. Among their duties, board members vote to adopt the township budget and oversee and approve various township financial matters. I believe Mr. Glassfener's bankruptcy filings and lawsuits involving some of these businesses are items material enough to impact voters' voting decisions. Because of these material omissions and questions about the filing, I believe his statement of economic interest, his CAN 12, should be discarded, declared void by this board. Under Indiana Code 389-5 and Indiana Code 3896, a statement of economic interest is required to be filed with candidate's certificate of candidate selection, which is the CAN 29, and was in the second packet of materials that was sent. A candidate's declaration of candidacy, and a candidate's declaration of candidacy, thus incorporating a statement of economic interest into both of those documents by reference and making the statement of economic interest a legal part of those documents. So thus, because Mr. Glassfener's statement of economic interest, his CAN 12 was void, his certificate of candidate selection, the CAN 29, as well as his declaration of candidacy and a written consent to fill a candidate vacancy, his CAN 31, are also void. In addition, Mr. Glassfener's candidacy is not effective for another important reason. Under Indiana Code 3-13-1-14, the selection of a person as a candidate to fill an early candidate vacancy is not effective unless the person's written consent, which is his CAN 31, is obtained and filed not later than when the certificate of candidate selection, which is the CAN 29, is filed, and the candidate has complied with any requirement to file a statement of economic interest, the CAN 12. When Mr. Glassfener's certificate of candidate selection, the CAN 29, was filed on July 1st, Mr. Glassfener's written consent, his CAN 31, was required to be attached to the certificate of candidate selection or filed before. It is written in bold right on the certificate of CAN selection on the CAN 29. Oddly enough, Mr. Glassfener's written consent, his CAN 31, wasn't attached to the certificate of candidate selection, nor had Mr. Glassfener's written consent, the CAN 31, been filed before the certificate of candidate selection, which is the CAN 29. Instead, his declaration of candidacy and written consent to file a ballot vacancy was not filed until July 5th, 4 days later. Under Indiana Code 354-1-9, any official responsible for receiving an election filing may not receive a filing that is offered to be filed after a deadline for the filing. The deadline for filing Mr. Grosvenor's written consent to fill ballot vacancy, his CAN 31, was when Mr. Grosvenor's certificate of candidate selection, his CAN 39, was filed. That is July 1st. When his declaration of candidacy should not have been accepted for filing on July 5th. Under Indiana Code 313-1-21, and any official responsible for receiving a certificate of candidate selection, which is CAN 39, may not receive a certificate of candidate selection if a declaration of candidacy, the CAN 31, filed by the individual selected as a candidate, or the certificate of candidate selection is or was offered to be filed after the deadline for filing provided by this chapter, or was not offered for filing at or before the deadline for the filing provided by this chapter. So Mr. Grosvenor's certificate of candidate selection, the CAN 39, should also not have been accepted for filing. Both Mr. Grosvenor's certificate of candidate selection and the declaration of candidacy were not permitted to be filed when they were filed and should have been rejected. Failure to comply with the statutory time frame means those documents were void and the candidacy is not effective and has never existed in the eyes of the law in the first instance. Any deficiency was not cured when the declaration of candidacy and written consent was filed later by itself. As described in Indiana Code 314-1-1, it is a campaign violation and a Class A misdemeanor if a person knowingly makes a declaration of candidacy or certificate of candidate selection, or knowingly files a declaration of candidacy or a certificate of candidate selection, knowing any part thereof to be falsely made, because it is required to be attached. Mr. Grosvenor's Statement of Economic Interest, his CAN 12, is a part of those documents. Under Indiana Code 36531, if the County Election Board determines that there is a substantial reason to believe an election law violation has occurred, it shall expeditiously make an investigation. I believe there has been a violation. Mr. Drew Wenger, then chairman of the Democrat Party, certified under item 4 on the certificate of candidate selection that Mr. Grosvenor written consent was attached to Mr. Grosvenor's certificate of candidate selection when Mr. Grosvenor's certificate of candidate selection was filed on July 1st, or had previously been filed with this office. Mr. Grosvenor's written consent, his CAN 31, was clearly not attached to Mr. Grosvenor's certificate of candidate selection when it was filed, as Mr. Grosvenor's written consent was instead filed 4 days later. Under Indiana Code 3-14-1-1, a person who knowingly makes or files a certificate of candidate selection, knowing any part thereof to be falsely made or filed, commits a Class A misdemeanor. The declaration of candidacy and written consent filed by Mr. Grosvenor has 2 corrections on it that were initialized by Mr. Grosvenor. Mr. Grosvenor initially indicated that he was a registered voter of the 9th precinct. This document was later corrected to show that Mr. Grosvenor was a registered voter of the 16th precinct. How did the need for this change come to Mr. Grosvenor's attention? When was that change made? Was it made after July 1st when it was notarized? If so, altering a document after it was notarized is a problem. Likewise, Mr. Grosvenor affirmed that the information set forth on his statement of economic interest was true and complete. Yet businesses were mooted and there were questions over his legal name, employment, and marital status. In his 2019 bankruptcy filing, Mr. Grosvenor indicates that he is not married. A search of the Indiana Marriage License Database does not reveal any marriage results for Mr. Glossner. Indiana has not recognized common law marriage since 1958. On his Facebook page, Mr. Glossner has indicated that he recently married in Brazil, which would explain the bankruptcy filing that indicates he was not married and lack of an Indiana marriage license results. However, according to the U.S. Department of State, the marriage process in Brazil can be complicated and time-consuming. A civil process is required to legalize the marriage. Religious ceremonies may be performed, but they are not legally recognized. Black's Law Dictionary defines marriage as legal union of a couple as spouses, and actual contracting in the form prescribed by law. So why does the legal name and marital status matter? Because he included it on his statement of economic interest, his K-12, and affirmed that it was true and complete. If he is not married, then including information about his spouse and his spouse's name make his statement of an economic interest false and inaccurate. If Mr. Glossner is married, then there is an issue with Mr. Glossner's legal name. Under Indiana Code 3574, if a candidate uses a name after marriage, the most recent name used after marriage is considered to be the candidate's legal name. On his Facebook page, Mr. Glossner uses the name Robert Glossner Bacchio. Is that how you pronounce it? Thus, under Indiana Code, if Mr. Glossner is legally married, then Robert Glossner Bacchio is Mr. Glossner's legal name. Mr. Glossner's legal name was then not used on his declaration of candidacy, certificate of candidate selection, or statement of economic interest. There is confusion over Mr. Glossner's legal name that impacts all his filing documents. Under Indiana Code 53577, if the candidate uses the designation on the ballot not permitted by Section 5 of this chapter, the candidate is considered to have withdrawn the candidate's candidacy. To the degree that he knew Mr. Biacco was not his legal spouse and put that information there anyway, and that he did not disclose all his business interests, he knowingly made a false statement on a document that was filed. Violating Indiana Code 31411 is a Class A misdemeanor. Under Indiana Code 3577, if the candidate used a designation not permitted by Section 5 of this chapter, the candidate is considered to have withdrawn the candidate's candidacy. There is also confusion over who is Mr. Glossner's employer. His statement of economic interest lists Third Generation Management as his employer. His bankruptcy filing lists Glenhaven Management Company, Inc., and states he was employed there for 3 years. His LinkedIn profile lists McDonald's and 27 years of experience from June 1995 to present. Mr. Glossner was involved in some capacity with a restaurant named Norita's Restaurant, in which he posted various posts on Facebook as recently as December 28, 2020, using the phrase "we," which to me denotes some sort of...
Minute left. 1 minute.
Oh, may I have additional time?
You have one, keep going, you got 1 minute left.
Oh, okay. Denote some sort of ownership or additional employment. These phrases included, we are offering an after Christmas special, and we have added some new items to the menu. Mr. Glossner also included copies of the restaurant menu. Norita was the name of Mr. Glossner's mother. The Monday, December 28, 2020 entry states, starting this week, we can be able to be serving brunch both Saturday and Sunday. In that context, Saturday and Sunday are referred to January 1st and January 23rd, 2021, thus indicating that this restaurant was operating during 2021. On July 1st, 2022, Mr. Glossner hosted a meet and greet party.
Time. Sorry, that's time.
3 minutes, extend for her 3 minutes. What does the board feel? Finish your commentary.
I'm fine with the additional 3 minutes. I'd like to finish up in that time period, though.
3 minutes?
I'll talk fast. On July 21st, 2022, Mr. Glossner hosted a meet and greet party at Fuse Bar and Grill in Chesterton, at which wine, soft drinks, and appetizers were provided. To the extent that the expenditures exceeded $500 $500, it's my understanding that Mr. Glassman needs to designate a principal committee under Indiana campaign finance law. As of September 7, 2022, I did not see a statement of organization for Mr. Glassman on the Porter County Portico website. Under Indiana Code 391-5.5, a local office exception candidate must file a CFA-1 form not later than noon 10 days after the candidate exceeds the $500 contribution expenditure amount under Indiana Code 591-55. Under Indiana Code 381-2, this board has jurisdiction to act with regard to any filing made with the election division. Under Indiana Code 381-2, the board may also deny a filing if the board determines that the candidate has not complied with the applicable requirements for the candidate set forth in the Constitution of the United States, the Constitution of the State of Indiana, or this title. Mr. Glassman's statement of economic interest is defective as it is materially inaccurate and false. Mr. Glassman did not include various businesses listed as active with the Secretary of State that should have been included. The form was also defective are those questions over Mr. Glassman's employment, legal name, and marital status. A materially inaccurate and false statement of economic interest document should be deemed void. Under Indiana Code 3896, the circuit court clerk shall reject a declaration of candidacy or certificate of candidate selection does not include a statement of economic interest. Thus, those documents should have been rejected, and Mr. Glassman should be drawn in candidate and removed from the ballot. Moreover, Mr. Glassman was vouched from the
1 minute left.
voucher from the information set forth on his filings were true and complete. Both documents were required to be notarized. Filing a declaration of candidacy or a part of it, which was false, is a Class A misdemeanor. Further to reiterate, under Indiana Code 313-1-14, the selection of a person as a candidate to fill an early candidate vacancy is not effective unless the person's written consent is obtained and filed not later than when the certificate of candidate selection is filed, and the candidate is filed with any required to file a statement of economic interest. Before an election, statutory provisions concerning an election are treated as mandatory. We are before an election. Mr. Glassman's name should be removed from the ballot, and this board should rule that his candidacy was not effective. Thank you. Sorry.
Thank you. Mr. Grosvenor, do you have anything you'd like to ask directly of Ms. Evans? All right. Board, do we want to open up questioning of Ms. Evans now, or wait till we hear now?
You ask questions now.
Okay. Floor is open.
Ms. Evans, what was the caucus date for this position?
There wasn't a caucus. They, actually, it was probably more a question for him, but it was an appointment. That was why there was a certificate of candidate selection.
I'd like, if I could, to ask the election office through the clerk to respond to several of these statements about timeliness related to some of the paper. If you could address that for us, please.
So, with the previous chairman, he meant well, however, most of everything he filed was incorrect in some way, shape, or form. And we did not hold candidates accountable for chairman's presentation of materials. So his Can 31 was originally included in his July 1st submissions from the chairman. I do have a time-stamped one. It was inaccurate. So we told the chairman that they needed to correct it and bring it back. However, July 1st fell on a Friday. July 2nd and 3rd, Saturday and Sunday, we were closed on the 4th. That is why he brought it back on the 5th. So when you requested the documents, they gave you the documents that would be on the website and official. Again, it is not uncommon for people, not just from this particular chairman, but from other people, to submit things. This is a different type of animal. And so, yes, the original packet should have included, and when you requested it, it should have included all documents provided, but it was originally provided. It was just inaccurate, and we sent it back to the chairman to have him correct it. And this is not the first time. So that explains the CAN 31 being file stamped with what you provided a couple days later than everything else. So that in itself isn't necessarily an error on the candidate, it's an error on the chairman. But it was provided in a timely manner.
I guess two things. My point would be is that you're saying this was the form then that was corrected and then resubmitted?
Yes.
So it still would be a bad on whoever resubmitted it because it was notarized as of July 1st.
Yeah, there's,
It wasn't copied and re-edited,
it was redone.
notarized, yeah.
So there was a separate, but you're telling me he found out later. When did he find out that it was wrong?
He found out on July 1st it was wrong. The chairman did. I don't know when the candidate found out.
But see, this is signed by the candidate on July 1st. So I think what you just did is you took the old form and crossed it out.
No,
Yeah.
I'm looking at both forms, and one of them is
Oh, you
signed and
have-
dated on 6/29, and the other one is signed and dated on July 1st.
Okay.
So no, it was not the same notary used both times. Or it could have been the same notary, but it was not on the same date.
Okay, well, that's,
So that in itself, you have other
right.
other
That knocks out
information
the
here.
campaign violation for him.
I just wanted to knock out the
Thank you.
CAN 31 and make sure all information was on the table.
Yeah, no, I agree. Thank you.
Mrs. Evans, just so
Yeah.
I can
Yeah.
get this clear in my mind.
Okay.
then, I'm looking at your original challenge that was filed with
Mm-hmm.
the board. As I see it, it raises one issue, and that deals with the allegation of misleading and inaccurate statements in the CAN 12. It sounds like as of today, you're making some additional arguments, including related to the filing of the CAN 31. Am I following that correctly?
What I am making, when I made my initial filing, I brought up that several things, I should get it in front of me. I brought up that problems with his name, which would still knock him off the ballot. I brought up problems with his marriage. Again, but what,
All in relation to the CAN 12, though, correct?
the CAN 12...
That's how I interpret your initial submission.
The CAN 12 is incorporated into all the documents that a candidate files by law. I can quote you, it's not on that, or is it?
It's okay, you don't have to, like I said, I was just trying to narrowly define the
Right.
issue, that as I read your original complaint, it concerned the
Gotcha.
CAN 12 and the CAN 12 only, and it seems like there's been some arguments that have developed that are new since that filing.
But the CAN 12 is incorporated into the other documents. And Indiana case law provides that an Indiana statute may adopt a part or all of another law statute by specific reference to the section sought to be incorporated. And those statutes do specifically reference the CAN-AM in many places, and I think I may have included that here or not. The campaign violation still regarding his CAN-AM would also stand as well if you were trying to confine it to just the CAN 12 as true and complete. I view this as if somebody had come to you and complained that someone did not file correct, or that they were not a voter registered, they would not be indicating a particular form. That would impact his entire packet of candidate filings. And your board has the right and the duty to investigate all of his candidate filings for validity and accuracy. So I think it's all fair game.
I'd like to ask a question. For Monica, the CAN 12 forms, the economic interest form,
Yes.
because the way I understood the statute is only required for statewide, state legislative, and judicial positions. So it would not be required to be on for the Westchester Township Board candidacy. That was my interpretation of the statute.
You've got for local and school board offices. Looking at what is defined as local, just a second.
And that may be only required with the CAN 31,
Right.
that they don't require.
And if you give me a moment, I'll look up.
I think precincts are not required when they're running for those offices.
So if we're discussing the CAN 12, as far as the marriage license goes, if it's an out-of-the-country marriage license, the couple has the ability to file it with the recorder, but it would not be in the state of Indiana database. It would not be in the Porter County Clerk's office. If they chose to record the marriage, it would be found at the recorder's office. I don't know that they have an online database. I'm not familiar with that office in that capacity, but that would be why you didn't find it in the Indiana database. Just to clear that out.
Thank you.
Out-of-state, out-of-country marriages are not filed within the county.
Thank you.
Clerk's office at least, or in the state database.
No, that's helpful. Hopefully, I'll never have to search for that again.
Right, I'm just trying to go down
No, I
the
agree.
line of
Thank you.
the CAN 12s, if that's what we're in agreement that that the original complaint was on.
Well, I don't know
When I
that
look
they
at
were.
when I look at the conflict of interest statute itself, they talk about the public servants who receive a commission through salary or employment. A public service interest in a contract or purchase of other contracts made with $250 or less, a contract from a utility company, a public servant who acts as a advisory capacity for a state college, but doesn't have the authority to act on behalf of the college. You've got a public servant who's under the jurisdiction of the State Ethics Commission, public servant who's not a member of the staff or governing body empowered to make contracts, can be appointed by an elected public servant. And there's some other qualifiers. Public servant is a member of a governing board of a hospital. You've got a and honestly, with your conflict of interest statement, one of the things is that if you have a public servant often, that they may not have disclosed something at the time of their filing for an office, but at the time they vote on a contract, then they would have an obligation within 15 days after voting on that contract to then file its conflict of interest statement, because maybe it wasn't done at the time that they actually took office, or the time that, a lot of your public boards will accept we'll do this on a yearly basis. Getting back to your question, David, I don't see.
I have the book and the page of the code. that
Okay.
references for his specific township board member.
Becky, you're gonna have to talk in the microphone.
In the candidate guide, as far as if it is required to be with the filing or not, on page 90, that is for township board member, and it states, I just had it. Just stating that the So 3-8-1-33 provides that a candidate for an office listed in subsection B must file a statement of economic interests whenever a candidate is filing a declaration of candidacy or nominated by petition, and this is specifically for the township board office
seats. And I think that was your question, was if it was required with the filing, and that states it is.
It's 3-8-9.
Can we go on? It looks like there's some more research going on.
I got a couple of questions. I'm under the impression that in your financial disclosure statements, everything, the only years that you have to reveal or they're pertinent that are on that form is the previous year. Is that correct?
That is correct.
So anything prior to that, any economic issues and stuff like this, don't have to be disclosed
Correct.
on that form?
Unless you're actively receiving something listed on this page for 2021 in this case.
Correct.
So yeah, when we're talking about like 2000, or like 2020, unless it went over into 2021, that's not applicable. It looks like
Yeah.
Requirement, which one goes?
it's only on, yes, and everything that was
The previous
accurate.
full year.
Yes. So,
Okay.
some of the things on here, I don't believe bankruptcy is relevant.
No, the bankruptcy is only relevant to show his intent for why he would not want this, perhaps.
Why would you think it important to this board to understand the intent of anything he does in his private life as opposed to challenging him on this form? That's one of my questions. I don't quite understand the narrative.
The narrative is why would that be important to have it appear on this form correctly? Why would you not just say, he didn't, my bad?
Can you show me where bankruptcy is required to be placed on this form?
Bankruptcy is not written, and if you read what I say, I give it only as an indication of why it would matter to a voter and thus be
We're
material.
not here as voters necessarily. We don't have a moral code to enforce here. We have an election code to enforce here. And so I hope that you understand the stuff that's outside the scope of this Can 12 is not the business of this board. His personal life is not my business.
It is when it impacts what's on
It
the
is
Can
not.
12.
As long as
Yes,
it is
the
accurately
Can
represented
12.
on the Can 12, we
That
don't
is
need to look
correct.
any further than
Only
that.
this
However,
document.
Then why didn't he put the businesses that the state of Indiana
We'll get
says
to
are
his
active?
well, and-
presentation.
right, and we'll ask him those questions. But as far as, some of the evidence being a LinkedIn account or a Facebook post, I mean, I don't think those are relevant in any way. I don't know that there's a mandatory statute somewhere to keep your Facebook and your LinkedIn account current. But again, if the businesses were operational in 2021 and he was receiving compensation, that would be relevant to the Can 12. But again, some of the items on here, as much as a voter, you might find them fascinating and interesting and want to make an opinion on or cast a vote one way or the other, that does not have anything to do with whether or not he's able and eligible to run for office.
That is correct.
That's up to the voter to continue looking and digging and doing their research about the candidates. That's not a part of this board or the Election and Registrations Office to do that type of research. That's for the voter to determine who they want to represent them on the board, is I think what we're trying to get across here. But you do bring some relevant points here as long as it is accurate that some of these businesses were running and he had compensation. Some
It
of them are
doesn't,
outside.
it doesn't say running in compensation, though. You're adding things that aren't there. If I
If
owned,
the business was closed, he no longer owned it. Correct?
if it's active with the Indiana Secretary of State.
And that's what
then-
we're going to ask him. Like I said, you brought some relevant points, but there's some that are outside of the scope.
No, I did attach them in my filing.
Yeah, I'm looking at your original filing.
So that was, You can ask, but the proof is right there.
My other question kind of dovetails off of what David had said about the possibility of a caucus. I know that in my previous life as a chairman and stuff, you had to have a copy of the minutes authorizing you as a county chairman by your organization to make those appointments. Do you guys have that letter on file, or was that a letter attached to that?
Provided with it was a ballot statement sheet by the deadline of July 5th.
Okay.
So it was the different boxes on that page of what took place in order for the candidate to be on the ballot, and it was that the chairman was allowed the appointment capability and provided.
And that clarifies the issue of the chairman have the authority to go ahead and make that appointment. I just want to make that point clear.
That wasn't
Because some people
included.
don't understand that. Yeah, I saw it.
Okay.
That's all that I have.
I
Anyone?
don't have anything further, Paul.
Mr. Banks?
Nothing further.
All right. Ms. Evans, thank you.
Thank you, and again, appreciate what you did.
Sir? When you're ready, we'll start the clock, all right? Take a deep breath and set yourself, and we'll go.
Before I get started, and I know we've got an 18-minute timeframe, I don't know if you have prepared statements or if you are just going.
I don't have prepared statements, but I did submit my legal marriage certificate, but it is in Portuguese, and so I do have it, a pastel copy of in English that I can give you guys my marriage certificate.
And we're going to be working now from this packet. This is your materials.
Sorry.
This is your.
That's part of it, yeah.
Okay.
I just want to make sure I'm looking at the right stuff. So this is the, sorry. So basically, a pastel copy of my marriage certificate from Brazil so that you can read it in English.
Thank you.
Because the original copy is in Portuguese. Do you need a copy of my marriage certificate?
Oops.
I'm sorry, I apologize.
Before he starts with the board, since there's not a prepared statement, are there any particular areas that you want him to make sure that he addresses?
Myself, I'd like you to address your employer as of 2021, and I'd like for you to address your relationship with, is it RWG LLC, doing business as Tan City, again in 2021. So if you could just touch on that one.
Yeah, I will definitely touch on that, but I do want to touch base, even though I know that you said that my past was impertinent. I feel like this is a witch hunt, and I do want to address the accusations that she made against me because they're absolutely false. And she would have done more research. Anyway, as far as my
If you're ready to start?
I am. Okay. As far as my marriage is, I was married in Brazil on February 15th, 2020. It was performed at their federal courthouse in front of a judge and her assistant. You can see by the marriage certificate that I gave you that it is a legal marriage, and the ceremony was performed by a judge. My husband is also here on a marriage visa, and he is a permanent resident, and very shortly, he will be a citizen. And because it was recognized by the U.S. government as a legal marriage, hence why he has his marriage visa, it is a legal marriage. And to indicate otherwise, because it wasn't registered with Indiana, is very offensive. As far as my employment, I do work for Third Generation Management, which is who I worked for. It is a private owner of McDonald's restaurants, which is why on my Instagram, I've worked for them. I'm not my Instagram, but on my LinkedIn, I've worked for McDonald's for 27 years. You know, and that's my experience of working with McDonald's. You know,
So
I've
is
worked-
Third Generation Management then as a franchisee
He's a
of McDonald's?
franchisee, correct. And, and prior to that, I worked for another franchisee for many, many years, a total of 27 years.
Okay.
So, just because it says third generation management, I wish you would have dug a little bit deeper, because again, I feel like I'm being attacked. So that was my employer. As far as, I had given you some legal documents from my attorney, Betsy Wallets. And as far as like that, the reason that I had to file bankruptcy on there was that my friend Tricia and I, we went into business with a married couple by the name of Chris and Lee Sampson. Our attorney drew up all the paperwork. We had them sign it. We had invested our money into it. And a couple days prior to us opening, they were delivering a truck order. Conveniently, Chris and Lee were out of the building, and I was there cleaning and preparing to get the business open. They were there to deliver food, and we were opening in a couple days, and they're like, well, I need someone to sign this contract, for the food. Called Chris and Lee, they're just like, oh, we're in downstate Indianapolis, making sure everything's finalized with the liquor license, can you just take care of it? If you don't, we're not gonna be able to open on time. Sure. I took care of it. We opened for a couple weeks. Tricia and I had already planned a trip on a cruise, went on our cruise, came back, completely different sign on the front of the building. They sold the business illegally, which is why the attorney sent out the cease and desist letter, which is copied in there, to the business. And then after the attorney went to go back at them, they agreed to buy us back out and consume all the debt, which would have been the Cisco bills. They dipped out, the attorney couldn't find them, court couldn't find them. My attorney said, you can't squeeze blood out of a turnip. It is what it is. Unfortunately, I had to assume the debt because I signed for it personally, and I had to file bankruptcy, which has not been something that I'm proud of. So thank you for bringing that up. And I am paying it back in full, even though I shouldn't have to according to the contracts. But I am filed Chapter 13, and I have to pay it back in full, and I made every payment. It was not my, no one wants to file bankruptcy, but I had to. Let's see, Naritas. It was a business that was registered, and, so when I was filling out the paperwork with Drew, we didn't get any help. Those, for a new-time candidate, it's hard to understand some of this paperwork. And so with no help, and at the last minute, I didn't list Naritas. It was, the last day of business was February 14th. On Valentine's Day, we had a brunch, and this was of 2021. We had a brunch. Nobody showed up for it because it was snowing extremely heavy, and I just said, I can't spend any more of my own money to operate this business. And so that was the last day of business, and the business was dissolved. When Cheryl Bonin, which is my bookkeeper, when her and I were trying to fill out the paperwork the best that we could fill it out, within the last year, I thought it was last 12 months. It wasn't. Apparently it was 2021. So that was honestly my mistake. It was not, I was trying to be deceiving or anything else like that. It was my mistake. There was one other business that was Anything Trendy, and I copied an email from Shopify. It was an online store. In 2021, it made 0 pennies, which is why I closed the town. So I got no income from Anything Trendy. Those were the only 2 businesses in 2021. When I got her challenge, I seen these other things. So in the past, I had made some LLCs for businesses that I wanted to start up, like any entrepreneur would, but there were no businesses with those. They were just LLCs. And my bookkeeper, who dissolved Naritas, went back, and if you go on the website right now, indiana.gov website, I am the agent of no businesses, and every one of the LLCs are dissolved because I just didn't know any better. And I'm not saying that's an excuse, but it is the truth. I'm not trying to be deceiving. That was the case. I just feel like when I got this challenge, and as I'm reading it, I was just taken aback, like how anyone would try to, she screenshot conversations from my Facebook page. She, as far as challenging the name, I don't believe there's any law that says I have to legally change my name when you get married. There's lots of women that don't take on their husband's last name. I don't have to legally do that. But just because I put it on Facebook, you know, she thinks that it should be a legal thing. It's social media, you know what I mean? And every document that I sign with Robert Gosviner is my legal name, and I have my passport to prove it, that it is my legal name. Robert Gosviner Bacolo, that's how you say it, was on my social media. It wasn't a legal document. I mean, I just don't know what else to say other than, this is just, I feel like it's just been personally attacking my personal life. I got involved in politics because I wanted to do some good. I had a friend who in LaPorte County held the same position for a couple terms. She said, Robert, you have more experience than I do in creating budgets. You know, I oversee $24 million sales worth of restaurants. I do their budgets every year. I make large purchases of HVACs and $30,000 purchases for equipment. You know, she's like, if you're gonna get involved in politics, this is a position I think that you should run for. And so I did. And then the next thing I know, I'm being challenged, which is something that I submitted also. I believe that they put it in there, that she has done in the past from other candidates that she's run against and lost, and she's challenged them in lawsuits as well. And like, I just feel like it's a witch hunt. I'm not trying to be deceiving. You know, she said it, you know, Drew was kind of absent a lot of the time. You know, we didn't get any help. And so this is where we're at.
Okay.
I really don't know what else to say.
Okay, we'll stop the clock there. Ms. Evans, do you have any questions, Mr. Gossamer, on his testimony?
On his testimony. So to reiterate, I guess, is that in 2021 you did operate 2 businesses, the Nothing Trendy, as well as the Narinas?
Was anything trendy, and I don't know if you would call it operating if you made 0 pennies. I mean, I gave you the financial statement from that. Not 1 penny was made.
You didn't, but okay.
Well, I didn't supply it to you, I gave it to them. I don't feel like my personal business is yours.
But yet you still did operate Naritas through February of...
Were you listening to my testimony? I just said to them that I was operating it until February 14th.
I was just trying to reiterate and clarify. Sorry, this is going to be so awful.
It's been awful for you?
No, for you.
You're absolutely correct, it has been awful for me.
Well, and who told you that I have challenged other things in the past?
Oh, after you decided to take screenshots.
That's not relevant here. Do you have any questions on his testimony?
No.
Okay, thank you. I'll open it up to the floor, or open it up to the board, rather, to speak. I'm going to start with a question. Do you know what it means to affirm a document when you sign it? I'm assuming maybe you do. When you filled out the CAN 12, by placing your signature on that document, you're affirming
I understand that.
the truthfulness of the document. Did you believe?
I believe that I filled it out correctly.
Thank you. Any other questions?
Did I miss where you discussed the WRG LLC? Was that another name that I,
No, that was an LLC from back in the day. So if you go to the Indiana website, all the LLCs that she brought forward were over 8 years ago, and no businesses were ever put underneath them. And again, if you go there, like today, as soon as I seen her challenge, I was like, oh, I don't use these things. So my bookkeeper literally went and we dissolved them.
so they were just like reserving the name?
Yeah, so like TNC, like I wanted to open up, there was a TNC that was open. I wanted to purchase TNC, so I made an LLC to purchase it, and then I just never purchased it.
So it's pretty much the equivalent of buying a website domain?
Basically, yeah. You know, I mean, I think of entrepreneurs trying to do that a lot. They make LLCs just in case they want to purchase a business underneath it, you know, and that was what the intention was, is I wanted to purchase the Tan City Tanning Salon, and it just never came to fruition.
So even though you had the registered LLC, there was no business for,
There was no business for it. There was no registered sales, there was no business for it.
And on the
Sure.
sheet 12, is there any changes then from the information that
Well,
was
I mean,
provided?
I guess like, if I could change it now, I would put Narita's on it, you know, even though it closed in February 14th, I guess I would change that.
So you mean it's closed, it's not active?
I'm sorry?
It was closed, you said?
Oh, it's dissolved. It's not
Okay.
February 14th,
What, 22?
no,
I
2021.
think, wait.
But
But there's
this
a
is filed-
difference between stopping and doing business and when it's actually dissolved with the Indiana Secretary of State. I think you said that it stopped doing business in
It
February.
stopped doing
20.
business on February 14th.
dissolved
but
at
it
a
was-
later date, though.
It was dissolved at a later date. But, I mean, she was looking at the post, you can see that the last post that was made was for February 14th. It was for that brunch. So that would be the change.
So you're still, the only thing you do is you do management for.
I'm an area supervisor for McDonald's restaurants. I oversee multi-million-dollar restaurants. I've done that for the majority of my life. You know, I've done things on the side like Narita's, and I was hoping to do something great with an online shopping store, which didn't pan out. But
You're not a partner in any other
I'm
partnership?
not a partner in anything, and then if you go to the Indiana,
Any liability company? You
no
said
more-
Narita's
there's
stopped
nothing.
business and now it's no longer.
everything's dissolved, agents are all resigned,
You're not an officer in the church?
not an officer in the church.
Your spouse is an officer or director of the church?
No, he's not.
I don't have any question.
so, since you said that even though it was incorrect, that you thought that it was within a 12-month calendar year instead of the 2021 year when you were filling out this document.
Correct.
Were any of these businesses open in any way, shape, or form on June 29th of 2021?
So according to the paper, that Anything Trendy, the one that made 0 cents, was dissolved on July 5th or 6th. So it would have been exactly that 12 months.
July what?
I believe it was July 5th or 6th that it was dissolved, but that, like, again, that business made 0 money that entire year, which I provided to you.
Monica, is there a date, had this been amended, is there a date that it would have had to have been done by?
The Can 12?
Can 12?
There is really nothing set out in terms of like an amendment date. You know, as I kind of pointed out earlier, when you look at the statute on your conflict of interest disclosure form, there's actually a grace period for somebody. Let's say that he ends up opening up a business in 6 months and it's not on this form. And something comes before the board and they approve a contract with the business that he owns. There's a grace period of 15 days to update and to file this after the final action on that contract. So what becomes a problem is when you actually vote on a contract for which you get some kind of economic interest and not having disclosed that you have an economic interest. That's the whole purpose of this disclosure, is that it's disclosed of any economic interest for which you are voting. Honestly, most of the time what happens is people will actually abstain from votes where there's an economic interest anyway. But you still want to, it's not to say that you wouldn't file an updated disclosure statement. You would do that anyway as well. So I guess that's a long way of saying that there is nothing in the statute that says, hey, when do I have to get this amended? You know, no later than 15 days after you voted on a contract for which you were going to get an economic interest would be the latest date that you would have to amend it.
When this position was filled, and I guess maybe if Drew were here, that'd be easier to answer, but were you at the meeting, Jeff, when the position was filled?
No, I was not. But what's the question?
Were there more than one candidate?
Basically,
Was only one person interested? I guess I'm not understanding.
yeah, more than likely what happens is, as a county chairman, someone will approach you past the deadline to file legally and say, listen, I'd like to run and stuff like this and everything. And you have until a certain date in July, I think it is, that you have to do that and stuff. Now, you can play games and try to sneak one in and you put it on the last day of filing or something like this, or you can do it right then and there when the person approached you and stuff. But this is all the paperwork you have to file. So someone probably, Mr. Cosner probably approached Drew to run for this position and stuff like this. And I mean, I always did my due diligence and make sure that I wasn't, setting myself on fire by putting somebody in there that doesn't belong in there and stuff, So you leave it up to the chair's discretion, and the chair does the best they possibly can, and,
Call the question.
I don't have any other questions.
All right, we have to move on this challenge. I guess we'll go to roll call and,
Well, Paul, let's do this. Let's
By
have a little
voice?
bit of discussion, perhaps. I think
Okay.
that would be helpful
Alright.
if we did that. Here's how I come down on this. It appears that there may be some deficiencies with regards to the filing of the CAN 12 and some of the disclosures specifically as it related to his membership interest in limited liability companies. From my side of things, I kind of got the sense that he's a serial entrepreneur that may have lost sight of things here a bit. I don't see this as something that arises to the level of invalidating his candidacy. I think that this, as I understand it, Monica, the statute is silent as it relates to the ability to be able to amend these type of filings, but it may be a good idea for the candidate to go ahead and seriously consider whether there's an amendment that needs to be filed here to rectify some of these issues. The only other comment that I have is member of an LLC, and again, Robert, you may want to talk about this with your attorney. Member of an LLC, that's an owner. It's member of LLC, or it's an officer or director of a corporation. Those are kind of some different titles that are thrown out there. Some of the documentation in it had references to Robert also being a registered agent. Well, chances are probably pretty good that if you're a registered agent, which basically you're the entity that receives any kind of legal notices that would be served on the corporate entity, that you may have an ownership interest. That doesn't necessarily mean that's one and the same. So that's a long way of saying that that's where I stand on things.
I have been very vocal that I don't like the idea of holding people 100% accountable when they're uneducated. I did that with the campaign finance reports, and we have courses, and if you don't go to the campaign finance report, well, now you're in trouble because you sent in an inaccurate report, and you didn't attend the training. I think this opens up another avenue of needing education, because these forms are difficult. I have filled them out. They don't make sense a lot of the time unless you're reading very detailed. So I think it's more of an avenue of lack of education, not just on the candidate part, but on the chairman part. But again, if it's able to be amended, and there's no deadline in the amendment, and there hasn't been anything wrong, it wasn't an act of business, it wasn't something, you didn't just not turn in the form at all. I think it errs in education and not so much on trying to pull one over on someone, or hide things from voters, or not submit accurate paperwork on purpose.
I think I agree with everything everyone has said. There's really no indication, given the testimony, that anybody was trying to fool anyone into running for an office that they really weren't eligible to run for. I don't think that was your intent at all. And I agree that you should amend your Can 12.
He probably needs to, I think as Ethan has pointed out, he needs to just, if he needs legal counsel or whomever.
Yeah, to seek it out, yeah.
Help him identify if he's a registered agent, he's an officer,
Yep.
or if he's a partner of an LLC, any of those roles, and sometimes that can be relatively confusing.
Right. If you need help in updating the Can, you need to get that help.
I do think it needs to be corrected, and I think it needs to be corrected. We can't fine or anything as far as I'm aware, but ballot deadlines are tomorrow, so maybe if it's not amended by then.
Can you amend it also, because those are due at the time of filing
Well, it's already been done once.
before the deadline?
Not if it's supposed to be, if it's supposed to be turned in with or before, it was turned in on the 5th, correct? Well, kind of, correct. No, that was the 31, I'm sorry, my bad.
I apologize, I have not been to the class on filling out those campaign finance reports that we've been providing, but if they don't have something in there with regards to filing out some of these cans and stuff like this, they are tricky. I've probably screwed them up as much as anyone and stuff, and then someone has caught it and said, Jeff, you need to get it. That's why you don't wait to the last minute to file a candidacy, because it gives you that little bit of a grace period and stuff like this to clean it up, fix it, do whatever you got to do. But we probably do need to kind of throw that into the education process, because these are very important. You're voting on things, and if you have a conflict of interest and stuff like this, with something that the office you're running for does business with and everything like this, you're putting yourself in jeopardy, and you're also deceiving voters. So at the end of the day, this is why this stuff is very important. But I agree with Jessica and everybody that's commented on education is probably the key part of this whole scenario.
And I do appreciate Ms. Evans bringing this to our attention. It's something that we haven't, as this board, gone through before. And it definitely shows where we,
Candidates need
if we're gonna
help.
hold people responsible, I think that we need to provide the education. And that's for chairmen as well as candidates.
Do you intend to address the issue that the Can 31 was filed after?
We already addressed that. It was originally filed incorrectly on July 1st with the rest of the paperwork. And then we asked the chairman to revise it and correct it, and he corrected it and submitted it again on the 5th. That was the first thing that we went over.
But it says that it has to be attached.
And it was attached. It was just incorrect. It was. It's timestamped at the exact same time as everybody
But
else's.
then the certificate of candidate final is not correct. Because that was filed on July 1st. And as under item number 4 on that, it says the written consent of this person to the nomination has previously been filed with this office or is attached.
Which form are?
And I think at
and
this
what
point,
number?
to interject myself.
What is the number on it? I can't see it.
Can 29, it's in bold type right there.
I can't see that far, I'm sorry.
It's in the packet, I know there's.
Can
one separate
29.
packet, I'm sorry.
I mean, at this point, I think that we are simply
Can 29
rehashing
file
the arguments
stamped
that have
July
already been
1st.
advanced here today.
Accurate.
If there's no further discussion, I'm comfortable in making a motion to deny the challenge in whole.
Do we have a second to that motion?
I'll second that.
Roll call.
President Roush,
Dismissed.
Vice President Lowe,
Aye.
He's voting in favor of the motion to dismiss it.
okay, I'm like, wait a minute, I don't know what that means. Member Banks,
In favor of dismissal.
Member Chittister,
In favor of dismissal.
Secretary Bailey, in favor of dismissal.
All right. We'll close out that piece of our business. Thank you both for being here. And we'll move on in the agenda to upcoming meetings.
We technically have a meeting scheduled next Thursday. Well, it doesn't really make sense to have back-to-back meetings. It does make sense to have one later on in the month. We were approved to have 2 additional full-time employees, and per the code, and per our code in the Indiana code, this board has to approve it in a majority, and they are set with the start date if we have them, if we have candidates that the directors are interested in hiring, of September 26th. So if we don't have another meeting until the end of October, that's an entire month that they can't work until this board approves them, so that they can be paid. And we would like to have them,
Is there action that can be taken in this meeting to address that then, Jessica?
no, because we don't have the candidate, we don't have the employee candidates.
Well, I mean, and I guess my thought would be, I mean, it would be approved subject to the director's approvals of the candidates.
Can we do that?
So you're granting her authority to hire, I mean, you have the positions already. You know what those positions are. So you're looking for a board approval to add these positions.
No, we've already added them, they've been voted on at the council meeting, we have the positions. Now we just need, in order,
Candidates to fill the positions.
we need candidates to fill them, and Sunday's been on vacation, so when she comes back, we have resumes that we're gonna go through and have interviews, but in our code, it says that I provide the candidates to the board for the director and the assistant director, the board approves them in a bipartisan majority vote. The directors get to hire the staff, but it still gets approved from this board in a bipartisan majority vote. If we don't have another meeting until the end of October, that's going to be problematic.
So I think that the question really, Ethan, is whether or not Jessica can go ahead and have the authority to go ahead and hire them, subject to final board approval in October.
Yeah, I think that's what Ethan was
Right.
proposing.
So they would be.
That would really only be that I could say yes,
provisional.
and then we could approve them.
Well, I mean, we could ratify it in October. I was just trying to, so you don't have to wait a month.
Right.
I mean, certainly I'm
If-
not gonna get in between you and deciding if these are suitable candidates or not. So, I mean, if those were identified, they were acceptable to you, I was gonna make a motion to approve that.
Yeah, I just think the best way is just go ahead and give her the authority to do the hire at this point in time, sight unseen. And then the board can come back and ratify those decisions in October. So you'll have to make a motion and.
So moved.
Second.
All in favor?
Aye.
Aye.
Opposed? All right.
Okay.
Does that mean we can do away with the next week's meeting?
Yes, so that means.
I'll miss you.
That means our next meeting will be October 27th.
Don't we have the public test before that?
We do, so we have a couple things, actually. We have a campaign finance class on October 1st, and we're also, while we have, we're all here anyway, we're gonna go ahead and bring some machines up in one of our mock elections, and we're gonna put it in the rotunda so the community and candidates and everyone who's not in the campaign finance class can come and get extra practice on the machines. We've still had some glitches and some people that aren't comfortable with them, so we're just gonna give another opportunity, just like we would at the fair. So that's October 1st from 10 to 12. Let me go back to my calendar. And then we have the public test on October 7th at 8 a.m. in the equipment room. I will have a proxy for that. Just a heads
October,
up.
you said 7th?
Yes. And then we have campaign finance deadline is October 21st, and then that's why we moved our meeting to be October 27th. So we'll have a list of
3
everyone.
o'clock.
Yes, 3 o'clock on October 27th. So we'll have the list of anyone who is late on campaign finance.
Oh, it's that time again already?
It is that time again. We thought we finished, now it's time to start up again.
All right. Other business before the board today?
Oh, early vote will also start within that
Early
time.
voting's
Early vote
coming,
will
yeah.
start within that time frame. We'll have to have the first absentee round out. So we'll have a lot of updates.
Okay. Public comment. Hearing none, I'll entertain a motion for adjournment.
So moved.
Second?
All in favor?
Aye.
Thank you.